Criminal Law 1, Joint Liability, Sections 34 and 149 of the Indian Penal Code in English language. Dear student friends, today I wish to take up in English most important topic from Indian Penal Code, Joint Liability, Section 34 and 149. In this lecture, we have to discuss about joint liability, which comes under two heads: common intention and common object. Section 34 deals with common intention and section 149 deals with common object. These two concepts, common intention and common object, deal with joint and constructive liability. This what is liability? What are different kinds of liabilities? I explained you in detail in law of torts while teaching vicarious liability, state liability, strict liability, no fault liability, etc. And also taught different kinds of liabilities in jurisprudence, namely independent liability, joint liability, several liability, strict liability, and so on. So this in civil litigation in law of torts, we studied joint liability under the head joint tort features. In contracts, we studied this joint liability under the head joint promisors. In criminal law, we study this joint liability as joint and constructive liability. Constructive liability in the sense the liability of one person as a consequence of wrong committed will have a link with some other person. So, the principle of vicarious liability may emerge in respect of common object. Common object. What is vicarious liability? How vicarious liability is unknown to criminal law? What are the exceptions? I will take up in separate class. So, in this lecture, I discuss separately what is common intention, section 34, and what is common object, section 149 under Indian Penal Code. This concept of common intention and common object, that is which deal with joint liability, will appear in so many topics, so many chapters. So joint liability, if a crime is committed by one person, he alone is liable, that is independent liability. Normally, while committing a crime, a person may seek the help or seek the company or help of another person or another persons. In such situations, if a person alone commits a crime, he alone will be held liable. When he takes the help of one or more, then joint liability will arise. So, when punishment is given in criminal law, same punishment is given to all the persons irrespective of their share in commission of the offense. One may commit 20% offense, other may commit 30% offense, some other may commit 50% offense, but the volume of punishment, degree of punishment will not be apportioned as per their degree of participation in the crime, irrespective of their participation in commission of the crime. All are held equally liable. That is why here we call it joint and constructive liability in criminal law. In law of torts and law of contracts, the liability is joint and several. Joint means if one person is joint in the sense, if all are sued jointly, all are proportionately liable. For example, three persons borrowed 3 lakhs from A.B.C, borrowed 3 lakhs from D, and at the time of repayment, D can file a case against three of them. Then three of them will have to pay 1 lakh a 1 lakh repay 1 lakh each. Suppose A alone is sued, A pays all the 3 lakh and he can recover 1 lakh each from B and C. That is why this in joint liability in civil law, that is both in tort. Suppose similarly in law of torts, in law of tort, A, B, C totally damaged the property of D worth 30,000. In the event case is filed, three of them have to pay 10,000 each. In the event one happens to pay, he can recover 10,000 from each. Suppose the two happen to pay at the rate of 15,000, both of them can recover at the rate of 5,000 from the C. So this is what is called in civil law, the joint liability is apportionable. In criminal law, this liability is joint and constructive. So this concept of joint liability, joint constructive liability in criminal law appears in so many cases. Wherever any crime is committed, it may be a theft, robbery, dacoity, murder, hurt, grievous hurt, whatever, for all the offences, if the number of accused is more than one, the picture of joint liability will come into the joint liability will come into picture. So if one in case the number is 2 and above, this joint liability will come. However, we discuss about a few topics. So basic before going to discuss these in detail, in what are the items in which this joint liability appear, we will have to discuss. There are several, but we mention here five instances. Number one, common intention. Section 34 to 38 of Indian Penal Code deal with common intention, which consists of joint liability. Secondly, common object. Section 149. Section 149. So this common object relates to specific offences like in unlawful assembly under section 141 to 160. If the unlawful assembly results in violence, it may result in riots and affray, criminal misappropriation of property. All these things I will take up in. First type of joint liability is common intention, section 34. However, section 34 to 38 of Indian Penal Code deal with common intention. Second one is common object, section 149. The definition of common intention and common object are same, but in 34 it is common intention, in 149 it is common object. So this in common object topic, I will explain everything in detail. Third situation of joint liability is criminal conspiracy. When two or more persons enter into an agreement to commit illegal act or legal act by illegal means, this is what is called criminal conspiracy, is what I told several times. And this first point, common intention, comes under general principle. Second point, common object, second concept, common object, comes under specific offences, because so many, it will the common object, fulfillment of common object may result in unlawful assembly under 5 situations under section 141. It may result in rights, it may result in affray, it may result in criminal misappropriation of property, it may result in mischief, like this. So various specific reliefs, specific offences may be resulted in if the aggravated form of unlawful assembly itself under section 141 is a specific offense. So third one is criminal conspiracy. Such as in 1913, criminal law was amended. Under Criminal Law Amendment Act 1913, Chapter 5A, consisting of section 120A and 120B, are added to Indian Penal Code. This criminal conspiracy, when also there are more than one person, two and above, enter into an agreement to commit illegal act, or legally enter into an agreement legally to commit an illegal act. So that is what is called criminal conspiracy. This is one way, this it is coined as principle, in other way it is studied as specific. So criminal conspiracy is both general principle, comes under general principle. It is instrumental for commission of particular specific offense. So it also appears as specific offense. For criminal conspiracy itself, a case can be filed as a specific offense. Just like negligence in law of tort, negligence is a principle but also specific tort. So for proof of any specific tort, negligence can be established as a principle. Similarly, for negligence itself, case can be filed. Negligence itself, case can be filed. Then the negligence will be treated as a specific tort. How negligence is being treated as both principle and a specific tort in law of tort. In criminal law, criminal offense, criminal conspiracy is being treated as both principle and specific offense. So first one is common intention, second one is common object, third one is criminal conspiracy, section 120A, 120B under the chapter A, Wide Amendment Act, the 1913 Amendment Act, 1913 Amendment, Criminal Amendment Act 1913, and fourth one is dacoity. Dacoity. So the fourth one is dacoity. So dacoity means if five and above, dacoity is one form of one kind of theft or robbery. So taking away one's property illegally. If one man takes away another's property illegally, it is theft. So there are 4 degrees of theft. So taking away property when the door is locked. Suppose without the knowledge of the aggrieved party, if the property is taken away, it is theft, pickpocketing, or when a house is locked, it is broke open and money and properties are taken. It is theft. When the inhabitants are there inside the house, the culprits knock the door and the inhabitant open the door, then they will point pistols, loaded guns or deadly weapons, and demanding them money and valuables, and taking them away in their presence. If they resist or opposed to refuse to pay, they may be killed or hurted, grievously hurted. So that is why, in order to avoid civil consequences, the inhabitant may give away all their money and property. This type of taking away property and valuables with knowledge is robbery. So robbery is aggravated form of theft. Serious nature of theft is robbery. Another aggravated form is theft is extortion. Extortion means if one person by creating fear, by inflicting fear on the in the mind of aggrieved, taking away money. So you have to give this much money, otherwise you will be imprisoned, you will be sentenced to death, like that. Creating such type of fear, or like just like blackmailing. If you don't give this much, your so and so will be kidnapped, your so and so will be abducted, and your house will be gutted, like this. Creating some sort of fear in the mind of another, taking the money, demanding the money, that is called extortion. Extortion, just like blackmail. And another fourth one is dacoity. If 5 and above persons attack the people and rob away, that is called dacoity. That is called dacoity. These aspects, sometimes dacoity followed by murder. So when dacoity followed by murder, and there the 5 and above persons are involved. So there are 5 instances. Next one, fifth one is a criminal trespass, house breaking in night. This also come under common object. So casually speaking, there are 5 situations. One is common intention, section 34. Second one is common object, section 149. Criminal conspiracy, section 128 and 120B. and decati followed by murder, section 396, 396, and fifth one is criminal trespass, house trespass, and breaking in the night. This comes under fifth. So though these are five situations, there are several situations in every crime in which more than one person is involved. The number of accused, the number of offenders is two and above, then joint liability will appear. If the joint liability, the number of persons is two and above, commit that offense with common intention, pre-arranged plan, same type of mentality, mind, evil intent, mens rea, that is common intention under section 34, whereas common object, five and above, assemble as a unlawful to commit an illegal act. When five and above gather together to commit an illegal act, that assembly is called unlawful assembly. Unlawful assembly. If the consequences are less, it is unlawful assembly. There are five situations in which an assembly becomes unlawful assembly. These five situations I will let you know, and let you know in that particular topic. And here, if the unlawful assembly becomes serious, results in violence and aggravated form, so many offences like rights, affray, and criminal misappropriation, mischief, and other offences may follow. So this is with reference to introduction of joint and constructive liability under section 34 and 149 of the Indian Penal Code. Before go, this is the overall idea of this topic, and before going to discuss common intention and common object in detail, let me take just half minute to pray God, pay homage to my reverend parents, late Rega Apparao, late Srimati Kantaratnam, my eldest brother Professor Rag Jaganmohan Rao, my wife Mrs. Balivada, late Balivada Tirumala Gauri, my academic associate. I express my gratitude to my godfathers who are instrumental for what I am now. I express my gratitude to all the authors and publishers in internet whose research papers and articles I am making use of to bring out this lecture. And finally, it's my primary duty to express my deep sense of indebtedness to my student friends who are mainly instrumental for what I am now. Now let us discuss about common intention section 34. Common intent section 34. In common intention, the number of offenders will be 2, and the maximum is not given, but 2 or above persons, 2 or above persons commit a crime. It may be a theft, robbery, dacoity, or any offense, murder, rape, whatsoever may be. When 2 or more persons commit a crime with common intention, same intention. So, the idea of committing crime, the desire to commit crime should be exist in the minds of all of them collectively, whether maybe 2 or 4 or 5, whatever may be. So, the intention of all the culprits accused is one and the same. That is, 2 or more persons sit together, A, B, C sit together. D has become a very problematic for us. So long as he is alive, we cannot shine in our life. Let us go and kill him. That is common intention. A, B, C, D, 4 are there. 4 are business people, for example. 4 are politicians. A wants to kill D, B wants to kill D, C wants to kill D. But they separately they are having idea. They never meet together. They never join together. They never meet and make a prior planning. That liability is called similar liability. Similar liability. For joint liability, there is a leading case. For joint and similar liability, there is another leading case is there. So that is why when 2 or more persons gather at a particular place with common intention, common idea to commit an offense. In the event the offense is committed by two and above, the result is fructified, all are equally liable. Out of these three, one has one's role is the 20%, second's one's role is 30%, third person's role is 50%, but all are equally liable. All are equally liable. Suppose A, B, and C have committed theft in D's house. A has stolen 20,000, B stolen A stolen 20,000, B stolen 30,000, C stolen 50,000. When once they are caught for a offense of the theft, all are equally liable for purpose sake. Suppose with these A, B, C go there, one tied hands and legs of D, A tied hands and legs of D, B killed with knife, C was waiting at gate to give indication whether anybody is coming. Fifth one is standing outside in a car to run away. If any noise produced to save them, to get all of them escaped. So the extent of participation is immaterial. So that is why meaning of common intention is when two or more persons with common intention, common idea, common mens rea wish to commit an act. If the act is committed, all are equally liable, as if one alone is committed. As if one alone is committed. A is committed for the whole offense, B is committed for the whole offense, C is committed for the whole offense. That is why section 140 was section 34 of Indian Penal Code says that when a criminal act is done by several persons, that is two or more, in furtherance of a common intention of all, each of such persons is liable in the same manner as if it is done by him alone. So according to this, when two or more persons, that is several persons, jointly commit a crime, irrespective of their share in commission of the offense, each and everybody is solely responsible as if he himself has committed that crime. That is. So this next principle, meaning is over, definition is over, then principle. The principle of common intention under section 34 is a principle because in section 34 comes section 1 to 120b are principles. Accordingly, section 34 is a principle of criminal law. It incorporates it incorporates the principle of law of evidence. It incorporates the principle of law of evidence and creates group liability. It creates group liability. This principle of joint liability or group liability was created or coined for the first time in a leading case, Reg versus Cruz. So why everybody should be liable equally? One commits less, other commits more. But of course, all the five, there may be 2%, 4%, 5%. The total act comes to 100%. One may commit 20%, other may commit 50%. Why each and everybody must be put to liability to the tune of 6 to 100%? The type of principle when once two or more commit, all must be made equally liable, irrespective of their share. This principle was coined for the first time in a leading case, Reg versus Cruz. So this is meaning is over, if definition is over, principle is over. Now elements to constitute, to invoke section 34 to attribute liability on all the person, to invoke section 34 to impose attribute liability on all the persons, all the accused, all the culprits. Four conditions are to be satisfied. First one is two or more. Second one is common intention, not similar intention. Third one is in furtherance of common intention or common design. Participation in the action is enough. Extent of participation is immaterial. So all these are out of these 4 points, 3 points are simple points. Common intention is to be explained in detail. First point is two or more. To invoke section 34 to impose liability equally among all, for there must be minimum two persons. There must be minimum two persons. If two and above commit the crime, then section 34 is attracted. Minimum two. And the minimum two persons should be there was quite there must be minimum two persons is two or more persons minimum two persons should be there. First point is overall. Second one is common intention. Common intention means the intention of two and above must be one and the same. The mind, there must be unification of minds. What is there in A's mind to kill D, B's mind to kill D, C's mind to kill D? That intention of all the persons is called common intention. This intention is otherwise known as desire, evil mind, guilty mind, mens rea. So all must the mens rea, that is evil mind or guilty mind to commit an offense must exist in the minds of all. That is the second point, common intention. Details I will explain. Third one is in furtherance of a common design. Suppose A, B, C want to kill D. So that is called three of them sit together. They speak about killing D. All of three of them agreed. Okay, we will kill him. That is today they are thinking. So acting in furtherance of common action in furtherance of common intention or common desire. Oh yeah, 2 days back we three sat together and discussed to kill D. Now let us now do it. Three of us sat together 3 days back, assembled together 3 days back to loot the bank. Let us do. Let us make preparation today. Three of us decided to unanimously consented to loot a post office. Let us take a preparation. So accordingly, they are going to prepare how to. They will make a plan how to go to post office or bank, how to loot the bank, how to go to this house, how to get. That is in furtherance of common intention. So fourth one is first the party two or more persons should be there is one point. Second point is they must have common intention, pre-arranged plan, prior mind, identity of minds must be one and the same. And third one is they should take initiative, they should take preparation. Just like there are 4 stages in commission of crime. First stage is initial intention, second one is preparation. Like that preparation is what is called in furtherance of common, acting in furtherance of common intention. So when once three of them or four of them, five of them go there to commit the crime, once participation is more, others participation is less. So for the reason that once participation is more, he will be held more responsible, and others participation is less, he is well held less. All are equally liable. All are equally liable. Just like that, A tied hands and legs, B killed with knife, 3 is say waiting at gate, 4 is seated in a car to escape from the scene of offense. Even then, when once one is caught, the one on the evidence given by one accomplice, then all the criminals will be convicted and awarded same punishment. So this is also. Now we have to discuss about this point, common intention in detail. Common intention in detail. There is a leading case on the point common intention. Barendra Kumar Ghosh versus the King Emperor, All India Reporter 1925, Privy Council, page number 1. So, On common intention, question may be asked on common intention. Other points are simple small points, but detailed information, just like stages of crime, mens rea is explained in detail. Other points are explained in a simple paragraph. Similarly, for common intention, out of those 4.2 or more, common second point is common intention. Third one in furtherance of common intention. Fourth point, participation is enough. Extent of participation is immaterial. Out of these 4 points, we have to discuss in detail about Barendra Kumar Ghosh versus the King Emperor. Barendra Kumar Ghosh versus the King Emperor. Here, what happened that Barendra Kumar, along with two others, went to post office for robbery. As a matter of fact, Barendra Kumar was not interested, but when two were going, he also joined them in that activity. And Barendra Kumar and two others went to post office. So this is Barendra Kumar Ghosh versus King Emperor case is also known as post office murder case or Shankaritola post office murder case. Shankaritola post office murder case or post office murder case. Barendra Kumar and two others went to post office to loot. Then since it is working, it is in working hour. So many customers were there. Customers were there in the post office. The postmaster, post office also, takes up banking business, receiving deposits and other NASH, NSC certificates and different kinds of deposits are there in post office also, like any commercial bank. And the money collected is being counted by postmaster, and he was in a room. And these Barendra Kumar and two others went to post office, and suddenly one of the three opened fire at postmaster. Postmaster killed on the spot. When once fire is opened, there is a lot of noise and disturbance created in the post office. All started running from out of the post office. In that process, the two other accomplices of Barendra Kumar ran away, but Barendra Kumar was caught. He was tried for murder of the postmaster under section 302 read with 34. 302 means 300 defines murder. 302 prescribes punishment for murder. But section 3 read with 34 means common intention. Under section common intention is there. Two or more persons are there. Common intentions are there. So to exhibit that it is the case of common intention under section 34, we use the term read with 34. Read with 34. Read with 149, we say that it is common object. 302. 300 defines murder. 302 prescribes punishment for murder as life imprisonment or death sentence. Accordingly, this Barendra Kumar was caught and prosecuted. In trial, Barendra Kumar contended that no, I simply joined them, but I did not open the fire. I did not kill the postmaster. You may examine my revolver, loaded gun. No bullet is used. No bullet is fired. So this is fully loaded. No bullet is spent. The bullet recovered from postmaster does not tally with the bullet of my gun, and it tallies with the gun of some other. So I did not commit crime. Then the court said that the Privy Council said, trial court, Calcutta High Court and Privy Council, all the courts did not admit his contention and held that when once you joined there, extent of participation is immaterial. So yeah, when common intention is there, your intention or their intention to go to post office and commit the offence, it is enough. This common intention is successfully proved, and he was convicted with death sentence. So this is what is called Barendra Kumar case. So it is to be borne in mind that to establish section 34, common intention is essential. It must be common intention. It should not be similar intention. Common intention is different from similar intention. If it is similar intention, section 34 will not apply. Here, for example, A, B are there. A is villain, B is A is one businessman or politician or somebody, some rich man. B is also some rich man or politician or film actor, and they want to kill C. A has intention to kill B. B has intention to kill C. But A doesn't know that B has intention to kill C. But B doesn't know that A has an intention to kill C. That intention is called similar intention. Similar intention. It is not common intention. One day suppose one day A and B meet together, sit together. Contextually, A expressed his vengeance towards C. Similarly, that vengeance of A is acknowledged by B. Okay, I too have a lot of vengeance. Let us take steps to kill him. That is what is called common intention. Common intention. So here this is the problem. Suppose A started from his house to kill C. B started from his house to kill C. When A reached B's house, when once A reached C's house, B had already killed him coming out of the house with blood-stained clothes. Then A will be happy. Okay, I'm free without any problem to me. My desire is fulfilled. It is done by B. In such case, B alone is convicted. A is not convicted. This is what is called common intention and common object. This type of case took place in Mehboob Shah versus Emperor. Barendra Kumar case was took place in 1925. This Mehboob Shah versus Emperor case took place in 1945, because even though Indian Penal Code was 1860, earlier up to 1950, our Indian Constitution came into force. This Indian Penal Code was applied to English courts, Crown courts, and other Privy Council was there. High Court of Calcutta, High Court of Madras, High Court of Bombay. 3 high courts applied these Indian Penal Code laws, and Privy Council followed this till the establishment of Federal Court followed this, and till the establishment of Supreme Court of India, British courts followed the principles of Indian Penal Code. So that is why there is a best example, relevant case on common intention, similar intention. That case is Mehboob Shah versus Emperor, 1945, Privy Council, page 118. In this case, what happened was, Mehboob Shah, this is also murder case. Mehboob Shah, Kashim Shah and Wali Shah are accused persons. Mehboob Shah, Kashim Shah and Wali Shah. Mehboob Shah is the owner of a land, Indus Valley. There was a Indus River. At the banks of Indus River, there was a big land. The owner of that land is Mehboob Shah. His nephew is Kashim Shah. His father is Wali Shah. Mehboob Shah is the owner of the land on the banks of Indus River. Qasim Shah is the nephew of Mehboob Shah. Wali Shah is the father of the Mehboob Shah. So one Mr. Alladad and Hamidullah. One Mr. Alladad and Hamidullah, these two men came to that Mehboob Shah's land through the river in a boat to collect reeds. Reeds mean those things, some sticks, flowers, whatever are fallen from trees and fell on the land. These they are called reeds. These Allah and Hamidullah came by boat, their boat, collected 8 bundles of reeds and loaded them into boat. In the first instance, the owner of that land, Mehboob Shah, shouted, "Don't collect the reeds." Then his nephew means brother's son or sister's son is nephew. brother son and paternal nephew means brother son, maternal nephew means sister son. So here his nephew Kashim Shah demanded, you give back you return the eight bundles of reeds collected. Then, in the meanwhile, when they were preventing, and some small fight quarrel took place between these two parties, Mahbub Shah, Kashim Shah, and Alladad and Hamidullah. Some quarrel took place. In that process, on that way, when Mahbub Shah father was coming towards their land, and Wali Shah opened fire at culprits, at Mahbub Shah. Wali Shah opened fire. Alladad died on the spot. His companion Hamidullah got injured. Here, uh, Mahbub Shah did not fire, Kashim Shah did not fire, but Mahbub Shah's father, Wali Shah, unexpectedly coming on the way, having seen the quarrel and fight, opened fire, and that Allah Dad died on the spot. His companion, Hamidullah, got injured. So here, this type of the land parties, the landowner Mahbub Shah, his father Wali Shah, and Kashim Shah, three are the accused. They were to be arrested. Wali Shah was absconded. Absconded. He left. Generally, when a crime is committed, the culprit leaves the place. He absconds. Then Mahbub Shah and Kashim Shah were arrested. Mahbub Shah and Kashim Shah were arrested, and they tried in a trial court, district sessions court. Mahbub Shah was found guilty and sentenced to death. Death. And whereas Kashim Shah, he did not open fire, and he simply scolded the party. He was sentenced to 5 years imprisonment. In trial court, Mahbub Shah sentenced to death. Second one, Kashim Shah, was given 5 years imprisonment. They preferred appeal before Calcutta High Court. Calcutta High Court confirmed the death sentence of Mahbub Shah, while Kashim Shah, Kasim Shah's 5 years conviction was lifted, acquitted. Kasim Shah is totally acquitted, but only Mahbub Shah is convicted, and his conviction, he preferred appeal before the Privy Council. While deciding this case, Privy Council made a big distinction between common intention and common object. Privy Council said that, enunciated that there is a substantial real difference between common intention and common object. While invoking section 34 of Indian Penal Code, it must be very necessary and carefully looked into the difference between common intention and common object. If it is not looked into in depth, and it a miscarriage of justice will follow. So here there is no common intention of the accused. There was no prior meeting of fire meeting. There is no prior meeting. There is no prior planning. There is no insidia in committing the offense. The incidentally took place. So there is no proper evidence to establish common intention in the mind of the two accused, Mahbub Shah, Wali Shah, and this. It suddenly took place, and this Privy Council, uh, while making a big difference between a drastic difference between these two, for on the benefit of doubt, dismissed the case, on the dismissed the death sentence, quashed the death sentence confirmed by the High Court, and this Mahbub Shah was acquitted in this case. But however, how far it is correct, we don't know. Privy Council, but here, however, in subsequent cases, common intention may appear, common intention may exist on the spot. Common intention may appear on the spot. So, what does this mean? Common intention generally means two or more persons meet together at a particular place, assemble, they discuss about the commission of an offense. It may be a murder, it may be a kidnap, abduction, kidnapping of a child, abduction of an adult person, adult woman, or a bank robbery, dacoity, whatever it may be. But the common intention, two or more persons may be there. Prior meeting, prior planning may be there sometime. So, of course, Supreme Court said common intention may exist, arise on the spot unexpectedly. So, how it? For example, A, B, C, three are sitting. So, they are just casually they are discussing about their personal matters. In suddenly one rival person are coming to attack, but one has vengeance with him. A has vengeance with B. D came there and he has cheated me a lot. He did me. Then B says, so kill him. You kill him there. So on this spot, the common intention is created. So A, B, C basically assembled, but they did not have any idea to kill D. Suddenly D comes. When D comes, A raised the idea of killing D. So B also seconded, 3 also acknowledged, and this common intention appeared 3. In that process, A attempted to kill, B attempted to kill, C attempted to kill. Or A, B did not attempt to kill, but 3 of them have given consent to kill D. One of them killed, then A, B and C are equally liable. This is what is called common intention may arise on the spot. This type of decision was given. This type of decision was given in Kripal Singh versus State of Uttar Pradesh. Kripal Singh versus State of Uttar Pradesh. The Supreme Court said that 1954. The Supreme Court said in 90 common intention may develop on the spot. Supreme Court in 1954 said that in Kripal Singh versus State of Uttar Pradesh, this case. So this view was followed by Supreme Court in another case, Krishna Gopal Patel versus State of Maharashtra. The Supreme Court said the same view in 1963. So common intention may be created from the beginning, and after meeting of 2 or more persons, suddenly the common intention may be created by them. But anyway, the intention should be acknowledged by each other. Mutual consent should take place from one another. Then it constitutes a common intention, followed by any criminal offense. For that criminal activity, all are equally liable, irrespective of their share in commission of the offense. So this is what is called common intention. This is with reference to common intention is over. Now we discuss about third point is action in furtherance of common design. So just like preparation, when 2 or more persons meet together, they want to kill somebody, they want to do robbery, accordingly they will prepare. Just like second point, preparation, acting in furtherance of common intention. Fourth one is participation is essential, extent of participation is immediate. Means the person waiting in a car at a distance to protect them, to facilitate the culprits to escape. If a person waiting with gate, he is also equally responsible. That is why extent of participation is immaterial. With this, common intention is over. Now we should proceed to common object. So far as common object, here common intention is general principle, common object is specific crime, Common object is specific right when 5% and above, 5 and above meet together with some object. See, desire to fulfill a particular result is common object. Suppose the rival party members 5 and above move to sit together to put down the government, uncrown the present ruling party. That is common intention. Suppose the government passed a GO, it will affect the interest of some group of people. They want to constitute as group and create communal form into unlawful assembly and to take various steps to and see that GO is not implemented. If any law is passed, that law affects some group of people, they may form together and start agitation. Such type of any agitation, when 5 and above form into a group to commit a criminal act with some common objective so as to benefit or facilitate some other person. And then when once their group, if the group facilitates some other person, the beneficiary will have the vicarious liability. Vicarious liability. Some one political leader is there. If that political leader is aspiring chief minister post, and he abets some group of people to create violence in a state, so that in order to crown their candidate as chief minister, then these people may create some problems, violence. Then ultimately, if any cases are filed, the person in whose favor these rights, unlawful assemblies rights, affrays and all these things are criminal misappropriation, mischiefs all take place, he will have to hold the responsibility, provided it is proved that with his consent only all these activities have been done. So this is what is called a common object. Common object, common intention, the definition is almost same, but in common, prior meeting of minds, prearranged plan is there by two or more person. Here common object is there to commit any to constitute into unlawful assembly. The aggravated form of unlawful assembly may be result in rights. Aggravated form of rights may be result in affray and all these things. So here, when once this assembly, 5 and above persons gather together to commit a criminal act, that assembly becomes unlawful assembly. What constitutes unlawful assembly is taught under section. So here, this common object may lead the criminal activity with common objective under 149 may lead to offences against public tranquility. Offences that affect the public peace and social security. Public peace and social security. You know, dear friend, at Ayodhya time issue, that area, the public peace is endangered, and sometime Punjab was facing lot of threat to public peace and tranquility. Sometimes Jammu and Kashmir subjected to lot of public peace and faced a lot of threat to public peace and security. So this unlawful assembly turns into violence, then it may be there. So here 5 and above persons, when five or more persons commit a crime in prosecution of a common object, each of them such group will be liable for that act in the same manner as if he alone has committed. 5 and above meet together with some common object and commit an offense. That assembly will become an unlawful assembly. An assembly is said to be an unlawful assembly according to section 141 under 5 instances. Number 1, this unlawful assembly the assembly becomes unlawful assembly if they want to create disturbance to against the government action. It may be government to the activity is against the government. The activity is against law passed by the government. The activity against the criminal act is against law passed by the government, GO passed by the government. The government passed a GO giving some facilities to some group, other group do not do it. So the government passed a GO declaring some castes as socially and academically backward. Some two, three castes are not included. Those two castes will demand to include it in that. So there be legislative action to oppose the executive action, or to act against the government, or to create or to public disturbance, and to threaten an executive, collector, or police officer not to do what he had to do. Suppose the government officer has to do some legal act, but they are preventing him to do legal act. But the government officer is not supposed to do illegal act. They are insisting him to do illegal act. So preventing to do legal act, or insisting to do illegal act. So there are five situations under which this criminal conspiracy against state or government, to against law or executive action, mischief means creating rights and mischief, destroying public properties, destroying personal properties, that is called mischief. Deprivation of property, entering into shops, taking away articles. In long back in Vijayawada, Andhra Pradesh, when Birla Ranga, one Ranga was murdered, I think. Then there was a lot of violence in city. So many shops were so many shops were looted. TVs and fridges were taken away. So many things. That is what is called deprivation of property. These are the situations, and unlawful assembly becomes unlawful assembly. If the assembly unlawful assembly is aggravated, becomes serious, it will result into rights. Rights means threatening public peace and social security. And affray in the sense, two groups, two leading groups in a particular area fight each other. When two leading groups in a particular area fight, suppose existing MLA, old MLA, say existing rich man and earlier rich man, and existing man, or some one person is, so a present man and previous man. So there are two big rival groups. There are two big rival groups, just like in movies, Samarasimha Harinde and others. So like that, the two rival groups are there, heads, they fight each other. It will create a lot of public disturbance and will inflict fear in the minds of the people. They won't be able to move out. So these are the consequences. If five and above commit any criminal activity with common object, this object is to benefit somebody, that beneficiary will hold the responsibility, that is vicarious liability for the consequences. Or for common object also, in general also, five and above may join together, commit an illegal act, and all of them are equally liable. If one is caught, all are equally liable, same offense. Suppose one unlawful assembly with common object, five and above committed the crime, only three are identified, two are not identified. The fundamental requirement for a common object is five, but once the commission of act is done by five and above, but only three are identified, two are not identified, 2 to 4 persons were not identified. They absconded, they ran away. Still, it constitutes common object. Common object under section 149, and even if the person who ran away not identified committed that, the person who are caught will be held liable, will be prosecuted and convicted according to section 149. This is the position. So there is a relevant case. So this view, even suppose, one thing is, suppose five and above should have some common object. Suppose five and above are sitting normally it has not yet been turned into vice. Suppose only one committed a criminal act, but four others do not have any idea or knowledge. It is not common object under section 149. The person who rose up suddenly and committed criminal act alone is responsible. That is independent activity 419. This was held in Queen versus Sahib Ali. That is the case is there. There are two important cases under section 149. That is T. Ramireddy and others versus State of Andhra Pradesh, 1988 Supreme Court. T. Ramireddy along with some others went to G. Mohan Reddy to kill him. T. Ramireddy along with his companions, his aides, he went to the house of G. Mohan Reddy. They broke open the door. G. Mohan Reddy opened the door. Rami Reddy and his followers attacked him with deadly weapons, sticks, and G. Mohan Reddy was killed. And they were tried for murder under section 304 I.P.C. I.P.C. Section G. Mohan Rami Reddy and others were tried for murder under section 302 read with 149. Trial court convicted all of them. On appeal to High Court, it was converted as 302 read with 34. It considered this, but the Supreme Court said that trial court contention was confirmed. So trial court 302 read with 149. High Court 302 read with 34. Supreme Court 302 read with 149. It confirmed the judgment of trial court only. So here whatever may be, all of them were punished and convicted. And another case, State of Andhra Pradesh versus Vedulu Veera Reddy. This is 1998 Supreme Court case. Vedulu Veera Reddy along with his friends, others, wanted to kill his brother. He along with others killed his brother, and all of them were convicted. The Guntur High Court, Andhra Pradesh High Court, and then Supreme Court convicted all of them. So this is the position with regard to 149 of the Indian Penal Code, dear friends. So I am collecting good information and giving you. So please make use of my lectures. It is a very rare opportunity to get in one lecture a lot of volume in a short span of time. I am covering nearly 10 to 12 hours, the whole subject as far as possible. If you make use of it, it will be very helpful to you. So I sincerely suggest you to watch my videos once. When once you watch, spare your valuable time, 1 hour in 2 days, and complete all the 225 videos uploaded so far. Out of these 225 videos, around 50 videos are in English media, but 175 videos are in English, and non-Telugu student friends watch these 175 lectures once in 2 days, one lecture in 2 days. Meanwhile, many more lectures will come. In any subject, any competitive exam, the number of subjects, papers will be, syllabus prescribed will be around 20, including enactment, hardly 15 subjects. So that is why I am taking up most important subjects and revising them. Ultimately, I wish to complete all the 30 subjects to the benefit of my students. So because I am taking up the giant project, teaching 10 minutes, 15 minutes is not possible. Some of my student friends are requesting me to speak in Hindi, upload in Hindi. It's my misfortune. Unfortunately, I am not able to speak Hindi fluently. Otherwise, I would be able to help a lot of students. Hindi, whose mother tongue is Hindi. Dear friends, I request you to tell your friends, and I also request you to arrange my videos in subject wise playlists. You will be a partner. What extent I am working, you are also will be able to help the law students. Don't feel anything. Even teachers also, if the subject is new subject, they have to take. If they watch my video first, my book or any book, or they can take the choose the best book of their choice. The preparation will be easier. Don't feel any agitation. No one is big, no one is small. I am taking the help of students articles who are studying LLB in law schools. I sincerely acknowledge that student as my guru teacher while taking the help of his article for uploading this lecture. Wish you all success. God bless you. Thanks a lot.